Let's dive right into this explainer and transform what can feel like super intimidating special education laws into your everyday toolkit for success. If you've been navigating the special education system for a while, you already know the deal. The endless paperwork, the dense legal jargon, the marathon meetings, it can honestly feel like you're stuck in a maze. But today, we're going to organize all of that chaos. Have you ever walked out of an individualized education program or IEP meeting feeling totally confused and just asking yourself, wait, why did they actually say no? Look, you are absolutely not alone. It's an incredibly common frustration. You ask for a service, an evaluation, or maybe a placement that you just know your kid needs, and the school team simply says no, leaving you totally in the dark about their reasoning or what you're supposed to do next. To get past that, there's a huge mindset shift we need to make. Your rights as a parent are not just legal protections for worst-case scenarios. They are practical tools. They aren't weapons you take into a battle. Think of them more like guardrails that keep your child's education safely on track. You definitely don't need to be in a bitter dispute to use them. Actually, understanding these rights helps you spot when things are working well and gives you the exact levers to pull when something gets off track. So here is the exact toolkit we're building today. 1. The rulebook covering procedural safeguards. 2. Your secret weapon, which is PWN. 3. Control and access regarding consent and records. 4. The superpower of professional documentation. And 5. The escalation protocol for dispute resolution. This is going to give you a super structured, clear path through the whole process. All right, let's open compartment number 1, the rulebook, also known as your procedural safeguards. Procedural safeguards are basically the master set of legal rights given to you by the Individuals with Disabilities Education Act, or IDEA. Now, if you're in New Jersey, you'll know this as the Parental Rights in Special Education document. I know, it's a massive read, but knowing exactly when the school is legally required to give it to you is step 1. They can't just hand it to you once in kindergarten and forget about it. You have to receive a written copy at least once a year, whenever there's an initial evaluation referral, if you ever have to file a formal complaint, or, and this is key, literally anytime you ask for it. It dictates how the entire process has to run. Moving right along to section 2, your secret weapon, otherwise known as PWN. PWN stands for Prior Written Notice, and it is a total game changer. The beauty of PWN is that it forces the school to pull back the curtain, meaning you never ever have to guess why a request was denied. Anytime the school proposes changing your child's educational program, or, critically, anytime they refuse a change you've asked for, they legally owe you this document. And they can't just give you a vague sentence saying the team determined this wasn't appropriate. If they do that, or if they skip it entirely, you have every right to demand a detailed version. A proper PWN has to specifically state the why, the exact tests they relied on, and the other options they considered but ultimately rejected. It completely forces transparency, which is incredibly useful for understanding the school's logic before you ever even think about escalating a disagreement. Next up is part 3, control and access. Let's talk about consent and your child's records. It's really fascinating to see exactly where your consent is required versus where it isn't. Under IDEA, consent is a big deal. It means you are agreeing voluntarily with all the facts on the table. Now, you don't need to constantly reconsent for standard annual reviews or minor IEP tweaks. But the school absolutely cannot do initial evaluations, start a brand new placement, do reevaluations, or release records to anyone without your actual signature. Plus, you always have the power to just say no to a proposed IEP. You can even revoke your consent for special ed services entirely, in writing, at any point. And the school cannot use a due process hearing to override you. You are in control. Of course, to make those big decisions, you need access to the data, right? Enter FERPA, the Family Educational Rights and Privacy Act. Under FERPA, you have the right to see everything: evaluation reports, progress notes, disciplinary records, the whole shebang. A pro tip here, always keep your own copies of these records. Build yourself a master parent binder rather than just trusting the school to maintain the only copy of your child's history. But how fast can you actually get your hands on those records? Well, the federal standard gives schools a pretty generous 45 days. However, if you live in a state with stronger local rules, like New Jersey, you have a major advantage. In New Jersey, you can expedite things by citing their specific rule, which says the school must provide access without unnecessary delay, and absolutely always before any IEP meeting or hearing. Knowing your state's specific timeline gives you a ton of leverage when you're gearing up for an important meeting. Let's move to compartment 4, the superpower. This is all about the magic of professional documentation. You absolutely do not need a law degree to be a fierce advocate. You really just need to be a meticulous note-taker. The goal here isn't to pick a fight with the school. It's to be an objective, professional partner who tracks the details. When you track dates, commitments, and especially those verbal concerns you mentioned that somehow evaporated into thin air, you are building an undeniable, factual timeline. A parent who is specific, persistent, and professional in writing is always going to be far more effective than someone who is just angry or vague. And here's the ultimate hack to do this seamlessly. Just send a simple email starting with, "Thank you for our conversation today. I want to confirm what we discussed," after every single significant meeting or phone call. It creates a really polite, non-confrontational written record. It gives the school a chance to clear up any misunderstandings, but more importantly, if they don't correct it, your email is now a time-stamped record of exactly what was promised. Finally, let's open Compartment 5, the Escalation Protocol, which covers dispute resolution. Now, most families are never going to need these formal options, but just knowing this ladder of escalation exists brings incredible peace of mind if good faith communication completely breaks down. You've got mediation first, which is voluntary and uses a neutral third party. If the school makes a clear procedural error, like missing a legal deadline, you can file a state complaint and have the state investigate. And finally, at the very top, there's due process, which is a formal, legally binding hearing in front of an administrative law judge. If you do ever have to pull the trigger on those formal options, you absolutely need to know about your stay-put rights. Stay-put ensures that the school cannot unilaterally change your kid's routine or placement while you're in the middle of resolving a dispute. Aside from a few extreme safety exceptions, your child gets to stay right where they are while the adults sort things out. Navigating that kind of escalation usually means you need some backup. An advocate is fantastic for everyday IEP negotiations. They know the process inside and out, they can sit on meetings with you, and they're generally much less expensive. But if you are heading into a formal due process hearing, you really need a specialized attorney. Due process is legally complex, time-intensive, and involves formal filings, evidence, and cross-examining witnesses. So, if you hit a point where you realize you need a lawyer, make sure you are hiring someone who specifically fights for families in special education law, not just a general practice attorney. Check directories like COPA or your state's Parent Training and Information Center. You want to verify that they primarily represent parents, not school districts, and that they actually know the players in your local district. Always ask them right up front about their recent due process experience and exactly how they structure their fees. We have covered a massive amount of ground in this explainer today, from demanding your prior written notice to writing that perfect follow-up email, all the way to understanding the ladder of due process. Remember, at the end of the day, you are your child's absolute best advocate. You don't have to memorize every single law. You just need to know how to use these practical guardrails. The system might be complex, but the power dynamic just shifted in your favor. So with all this in mind, which of these tools are you going to use at your very next IEP meeting to make sure your child gets exactly what they need?